Hi, my name's Isaac Shutt. I'm an estate planning attorney licensed both in Texas and in Wyoming. And now I'm going to answer a question that is one of the most popular, and that is, do I really need a will? Well, it's a great question, and it's slightly different than another video that I have where I talk about, am I required to have a will? And of course, the answer to that is no, you're not required to have a will. But this is more like, is it a good idea to have a will? And the answer to that is generally yes, it's a good idea for you to have a will. But there are some times where I say, maybe the answer is maybe. And what I mean by that is sometimes people pass away with just very basic assets like money in a bank or maybe a retirement account. And those can be controlled with beneficiary designations. Of course, you want to make sure to go one layer deeper and not just have one layer of beneficiaries, but an alternate, because people may pass away before you and you want to make sure to have some redundancy there. But if that's really all you have is an account or two, and those have beneficiary designations, maybe it's not as crucial that you have a last will and testament. Now, even if you have something like a trust, you should still have a will because you have other assets, and if there's some loose end that needs to get tied up, we really want to make sure that that client has a will in addition to that trust. And also, if you have any real estate or really anything other than an account or two, you should really consider having a will. Because even though there are things like a transfer on death deed or a ladybird deed or things like that that would appear to successfully transfer property interests, like real property interests, upon your death, in my mind, that's not good enough because a title company may ask for something else other than that transfer on death deed after you pass away. And that's not such a big deal if you have a last will and testament, but it's a huge deal if that transfer on death deed or ladybird deed didn't work out after you pass away and you had no will. Becomes extremely expensive for the family, very costly in a probate court, and also really lengthy in probate court. So even if you have a transfer on death deed or ladybird deed, if you own real estate, definitely consider getting even a basic last will and testament. And even better yet, consider having a last will and testament done by an attorney just to have that extra measure of safety and peace of mind that would come from knowing that it was done correctly. So anyway, just again, to sum it up just real briefly, do I need a will? The answer is, if you own anything other than an account or two, the answer is definitely yes. If all you have is maybe an account or two, the answer is maybe, but be really certain that you have your beneficiary designations and at least one layer of alternate beneficiaries listed on those accounts. I hope you found this video helpful. Again, my name's Isaac Shutt. I'm an estate planning attorney licensed both in Texas and in Wyoming.